one of the primary constitutional rights that all Americans have, all people have, is the right to privacy. Right to privacy means that there's certain things that you keep private. That is not something that governmental authorities should have access to. And now where that comes from in the Constitution is somewhat problematic. The U.S. Supreme Court in the Griswold case, first enunciating this right to privacy, said the justices disagreed. What they all but two agreed on is that there is a right to privacy. As I said, it's based on this notion that there are just certain limits that the government ought not to go into, or constitutionally prohibited from doing so. So one of the things that students have, for example, in the dormitory is a certain privacy that the police, campus police or Asheville police have to follow certain strictures of the Fourth Amendment in terms of if there's some sense that maybe there's criminal activity. There's a warrant requirement, there's probable cause. The issue that's come before me through one of my students is about how much information that RAs should have about their students and who they're reporting that to. I think we are all agreed that what we want is information about students that if they would harm themselves or harm others, that's information we have to catalog and take action. But there are other things, for example, the organizations that a student belongs to, who the student is friends with, that kind of information most of us, if not all of us, want to keep private. So what concerns me here is that the administration or the university is perhaps attempting to get private information or information that would be protected by the right to privacy. Really, for me as a constitutional lawyer, the standard here is what is constitutionally permissible. I mean, from a policy point of view, not a legal point of view, from a policy point of view, one of the things you want to encourage is an interaction between the RAs and the students, and where they feel as if there can be a free and frank exchange of ideas. But what I'm talking about here is when we go from mere discomfort, if I could phrase it that way, to entering into the realm of students' lives that invades this right to privacy. And it's not a clear line, right? It's not this line that you can say having this kind of information is permissible, having this information is impermissible. But what we have to be cognizant of is to protect the privacy rights of students here. And I think the concern of the RAs I have talked to, and I've only talked to a few, but the concern that they have had is that they're moving from those things that are, let's say, public knowledge or things that students would want or wouldn't mind being known, to the realm where students are finding that some of their private thoughts and their private associations are being known to others. And it's that concern with the RAs that I've talked to. We've moved from the permissible to the constitutionally impermissible.